Welcome back, everyone. Thank you so much for returning to Finding the Right Floor. And thank you to those who are joining us online. I'm going to go straight into it and introduce you to the moderator of our next panel, Maggie Blackhawk. Join me in welcoming Maggie and the rest of our panelists.
All right. Good morning. Oh, wait. Good afternoon. I'm still in Arizona, I think. Okay. Let's see here. Bonjour, Maggie Blackhawk Indigenous. My name is Maggie Blackhawk. I'm Fond du Lac Band Ojibwe, and I also teach law at the NYU Law School. And today it is my great pleasure to invite you to our afternoon panel with some incredibly distinguished speakers. And I'll get to them in a moment in their introductions. Some of them I've worked with for decades, or at least known in the ether of federal Indian law litigation for decades. And I'm just delighted to even be able to listen to their remarks today. All right, so our panel is How to Read a Treaty, Legal Battles and the Continuing Impact of U.S. Anishinaabeg Treaties. So this panel will demonstrate how important Michigan-era treaties such as the 1836 Washington Treaty and the 1855 Treaty of Detroit continue to shape the lives of the Anishinaabe people of the state, and how their meaning, these treaties, and their enforcement remain subjects of legal challenges and political activism. To show the continuing impact of treaties and the ways in which they serve as foundational documents of U.S. Anishinaabeg political and legal relations, our speakers will collectively draw from their experience as legal scholars, jurists, litigators, and expert witnesses. Collectively, they'll discuss cases such as Little Traverse Bay Bands of Odawa versus Whitmer, which considered whether the 1855 Treaty of Detroit created a reservation for the LTBB Odawa in northern Michigan, as well as current litigation on the Line 5 pipeline in the Straits of Mackinac and the broader historical context of these cases. So our panelists are incredibly distinguished, so distinguished that we've printed their bios in full in the program for you. This evening, I hope that you take not just 5 minutes, but maybe a half an hour to reflect on their contributions to these fields, because they really have been path breakers. There's a little bit of sarcasm, but there's actually a lot of truth to what I'm saying, to see the work that these folks collectively and individually have done to shape the field of federal Indian law and truly contribute to Indian country over decades and decades of expertise, research, and really hard, oftentimes very difficult, challenging loss after loss work. So we'll begin our presentations today. So I'm going to introduce the panelists in the order of their presentation. We'll begin with Dr. James M. McClurkin. So he's the founder and president of McClurkin Research, and he has studied the history and culture of Great Lakes Indigenous communities professionally since 1977. That temporality should give you some idea of the scope of his contribution, but geographically, he is well known to the tribes of Minnesota for researching and almost not single-handedly, but collaboratively contributing to many Supreme Court cases and lower court cases on treaty rights in Minnesota, and I'm sure he is similarly well known across the Great Lakes. Riaz Kanji, he's a founding member of Kanji Katzen, a firm whose mission is to advance tribal sovereignty. His firm is really the boutique litigation firm of federal Indian law. And I first, not met, because I've actually first met Riaz for the first time in person right now. But I think maybe 16 years ago, when I summered for the Tribal Supreme Court project at the Native American Rights Fund, Riaz was the voice in the conference call box that really shaped federal Indian law appellate litigation for the last so many decades. I can't even begin to thank him for his contributions to Indian country. I have no idea what possessed him to take on losing case after losing case. There are other areas that would have brought many more wins to his docket, but we're all very grateful that he took the challenge on and is hopefully very happy with his successes. And lastly, but definitely not leastly, Professor Matthew Fletcher, who is the Harry Burns Hutchins Collegiate Professor of Law and Professor of American Culture at the University of Michigan. He is an expert and the renowned leader in the field of federal Indian law, American Indian tribal law, an area of law that he has really founded entirely. Now that he has many acolytes, but he really single-handedly founded decades ago. And he also specializes in Anishinaabe legal and political philosophy, areas of law that he has informed with deep practice experience as a tribal judge for tribes across the Great Lakes, as well as into the Northeast. And I'm going through the very long list into Oregon, the Tulalip. So I really reflect on these folks' contributions, but I'm grateful for their sharing their expertise with us today. So please join me in thanking the panel, greeting the panel.
I'd like to thank the organizers for inviting me to serve on this panel. I don't go out and speak very often, but I am never invited to speak on a stage with such illustrious people who I respect so greatly, people I have worked for and with and who have shaped how I read treaties, believe me. But I've also helped their practices. I start off a job by telling them, no, there is no smoking gun. All I had to start this presentation with was a title, How to Read Treaties. And I thought about it, and I thought about Indian treaties and all treaties and what's common with Indian treaties. And it's that they're all written in ambiguous language. All of them have ambiguous language. That's why American Indian law has a standard called the Canon of Construction that says that treaty court cases are to be interpreted in the light of ambiguous language in a treaty is to be interpreted in the light of the way the Indians understood it. And my career has been focused on trying to understand how Indians understood the language. Ambiguities inherent in all diplomatic agreements between parties with incompatible goals. And we've already heard how incompatible the goals of the United States and the Indian tribes were. In every single treaty, we've discussed the treaties for the Ohio Valley, we've discussed the treaties all the way up through the Great Lakes, and it's all the same. The government came, they wanted to acquire land. They wanted to lay a grid survey, they wanted to sell that land, they wanted to turn that land into property. At the same time, they wanted to minimize conflict, and that was their goal. Pacify the natives, minimize conflict, and bring in settlers to enforce the sovereignty of the United States. I'm looking at language in the Potawatomi Treaty here because we left the Potawatomis out of our program, and we have an illustrious tribal council member of the Nottawasipi Band here. Their goal is to preserve their access to the land for their own subsistence. Not a single tribe who signed a treaty with the United States ever signed a treaty saying, we're going to go away and disappear now. They all wanted to be alive. And they all wanted to retain the rights to continue hunting, fishing, and gathering. Because if they did not, they would not have any way to make a living on the edge of the frontier. And all of the treaty language incorporates all of those things in a hodgepodge. At the heart of the ambiguous language in the Potawatomi treaties is the word property. The Potawatomis reserved the right to hunt, fish, and gather on ceded lands, most often while it remains the property of the United States. Not once does the treaty define what the word property means. Now, if it was written by a lawyer, oh wait, most of those treaties were written by a lawyer named Lewis Cass, he would put in the definition of property, right? No definition of property. Property can mean sovereign jurisdiction. Property can also mean individual land title, but it's just not there. The federal government didn't care, really. Lewis Cass didn't care. His assumption was that the Indians who stayed east of the Mississippi River would soon become farmers. The rest would move west, or they would simply cease to exist. The ambiguity to him wasn't worth his time of thinking. They would simply not be a problem after the 1830s. The Potawatomis had a different idea, and the Potawatomis believed that they were sovereigns. They intended to keep their sovereignty and maintain their rights. They would never have agreed to a treaty that limited their right to hunt, fish, and gather, because that would have meant economic disaster. The language is so peculiar in the Potawatomi treaties that it's a moving target. The Treaty of Greenville, which ceded all of southern Ohio, as we've seen, the Indians had just fought the United States to a draw. They met with General Wayne at Fort Greenville. Greenville made agreement with Potawatomis and other tribes that they would recognize the sovereignty of the United States over their affairs. It would preserve their right to hunt, fish, and gather on ceded lands so long as they did so peaceably. In 1803, General William Henry Harrison, on the Thomas Jefferson administration, introduced a new language. The Sauk and Fox ceded, I think, about 8 million acres of land in a document they didn't even know was a treaty. They didn't know they were coming together to make a treaty, and they signed a treaty that allowed them to hunt and fish and gather on the lands while it remained the property of the United States. There's no journal, there's no correspondence before, there's no correspondence after. There's nothing in any trader's records, there's nothing anywhere that said what it means, not then, and not for the next 50 years after. The Treaty of Detroit, the 1807 treaty. General Hull, who's the governor, as long as they remain the property of the United States, just picked up Hull's language, brought it to Michigan, dropped it in a treaty, and there it stands. There's nothing about it. The Treaty of Chicago, a Lewis Cass fine document. Leave it to him. He mixes up everything. Cass combines both terms. They can hunt on the land, which is south of the Grand River, much of southern Lower Peninsula. They can remain on those lands while they're the property of the United States and while they behave themselves peaceably. And the Treaty of Chicago, 1833, they shall not be disturbed as heretofore. What does that mean? We got ambiguity. I'm going to get a minute, talk to in a minute. And besides, precision was never the goal. The goal was to take land, and the preserving of hunting rights helped overcome tribal opposition and gave the tribes time to assimilate into an American vision of what they were supposed to be. But there's another critical piece of context here that's legal, and I'm not a legal guy, but the United States law is different than British law. In British law, all the wildlife belongs to whoever holds the title to the land. But the United States is different. It's a democracy, and the resources belong to the people. There's no restriction that ties wild game or any other resources to land title, ever. If a piece of land is fenced, then you can't hunt on it. And Lewis Cass wrote the first 3 fence laws of the state of Michigan, and he knew that. The first issue was not about hunting and fishing. It was about maple trees. Until the United States invaded Cuba and took over Cuba, sugar was one of the main exports in Michigan. Maple trees down by Coldwater. The Potawatomis made tons of maple sugar and sold it from Detroit. When settlers came, settlers had no money. They made tons of maple sugar from trees that the Potawatomis had used for years. There was conflict. And here is where the 1836 treaty language comes in. It's the first time, 1837, years after the Potawatomi treaties were made, when the United States ties the end of the right to when the land is surveyed and sold. It's hard to say that the people who made the treaties before that would have understood the right to have passed when title was sold, when it wasn't even a concept invented. The Potawatomis continued to hunt, fish, and gather throughout the 19th century. They did so pretty much without hazard to themselves, but by the turn of the 20th century, Michigan's unextinguishable game collapsed. There was nothing here. The ecological degradation, the overhunting, fishing, sport of killing had wiped out every population in southern Michigan. Conservation officers targeted areas to enforce laws, mostly around Indian reservations. And the Potawatomis were no exception. The Potawatomis started bringing cases to court, local courts, and they failed over and over again. There's a record in state courts and federal and local courts. But in 1971, the Bay Mills Indian community brought a case called People v. Jandro in the Michigan Supreme Court, which ruled that federal treaties supersede state laws, which was a huge shift for everybody. All of the tribes in Michigan claimed treaties as the basis of their right, and the Potawatomis were right at the forefront of that. When I started working, there were only 4 federally recognized tribes in Michigan. There are now 12. 3 of them were recognized by legislation in Congress. The Pokagons were one of them. Pokagons, Little Traverse, and Little River all have lines in their legislation that says that all treaty rights that belong to the tribe are restored to the tribe. As of 1994, the right to hunt, fish, and gather has been restored to the tribe. Thank you. Oops.
Good afternoon. It is such a privilege to be here. I'll apologize at the outset. I don't know how to do PowerPoint, so you're stuck just looking at me for the next 10 minutes. I'm very sorry. It is such a privilege to be here and to have been invited. I have loved my career of representing Native American tribes in litigation, and I would say that the thing that I enjoy the very most out of practicing in this area is the opportunity to work with wonderful historians and to be involved in history in pretty much every aspect of what we do. And one of the key points I want to make is that history infuses all of our litigation on behalf of tribes. I think the cases where we are not talking about treaties and history are an absolute rarity across a broad range of subject matters, everything from treaty fishing and hunting rights to reservation boundaries, to land claims, and even to modern day issues like business development and gaming, we are always talking about tribal history and tribal treaties. The very first case that I did in Michigan, where I had the privilege of working with Jim, was a case for, and actually with Matthew, who at that point was a very young lawyer, was a case for the Grand Traverse Band about the legality of its Turtle Creek Casino. That case involved delving into the history of the Michigan tribes and the 1836 and 1855 treaties, because under the federal gaming law, the tribe was able to game there if the lands were lands that had been restored to the tribe. And that kind of vague phase in a statute meant that we had a license to really delve into the history of the tribes. Over time, I've had the privilege of working with many wonderful historians. The very first case in my career, I was spoiled because we worked with Richard White on a treaty shellfishing rights case out in Western Washington. I've had the privilege of working with Greg Dowd on inland fishing and hunting rights cases here, John Parmenter on New York State cases. So it is something that we truly enjoy. Why are historians so important to the work we do? Jim got into this in his presentation. Often the treaty language that we are dealing with is very terse. It's often vague. These treaties, as everyone knows in this room, were written under conditions where that did not lend themselves to detailed, long documents. And when you were talking about people negotiating in different languages and the great imbalance of power and the desire of the U.S. negotiators to get the treaties done and to move on, what you are left with is language that really requires sophisticated historical interpretation. One of the things that I've learned throughout my career is you cannot take treaty language at its face and think that you understand what it means. The very first case I worked on, the case with Richard White, was a set of treaties in Western Washington that reserved to tribes the right to take shellfish so long as they were not taking shellfish from beds staked or cultivated by citizens. And the other side, in the case of private property owners, the shellfishing industry, said, well, it's clear what that means. If you have shellfish beds and we have put stakes around them, and we are cultivating the shellfish, we are farming the shellfish, that means that those beds are off limit to the tribes, which would have been the vast majority of shellfish beds in the Puget Sound. But Richard delved into the history, and it became very clear that at the time, that phrase, staked and cultivated, had a well-known meaning within the shellfishing industry. And what it referred to were artificial beds of shellfish, beds that were made, man-made, where there were no natural beds, because under the laws of the time, the well-known understanding of the time, you could not stake and cultivate a natural shellfish bed. Those were open to the public. So when that treaty was written, that was the understanding. But it took a great deal of historical explication by an expert of the caliber of Richard White for us to be able to convince the court that that's what it meant. That case was also, I think, a very good example of why history matters so much in our cases from the opposite point of view, which is that in our litigation, of course, it's an adversarial system, we always have competing stories. And history is about telling stories and constructing narratives. And as we all know, you can construct very different narratives based on records and facts. And in that case, the state of Washington's historical narrative, and I'm really not exaggerating, was that the time period when these treaties were signed, 1855, this was a very tough time for the tribes in the Puget Sound area. They were on their heels. Settlement had come in. There was widespread disease that had been brought by the settlers, and the tribes had essentially given up. They were fatalistic. They didn't think they were going to be around for much longer, so they weren't negotiating very hard, and they really didn't care. And so they'd given up. They'd given up all their rights. And so the treaties should be interpreted in a way that really favored the settlers and the state's interests. Now, of course, nothing could have been further from the truth, and the treaty record was replete with just how strongly the tribes insisted on reserving their fishing rights. But that was the counter narrative, and it is critical in our cases that we work with historians who can tell the narrative, construct the narrative, and tell it with greater force and power than the other side. Another example of this, and this goes to the treaties that we worked with Greg on, but the 1836 Treaty of Washington that Jim referred to, which is the cornerstone treaty for 5 Michigan tribes that surround the Straits of Mackinac, both on the north and the south. That treaty does not actually mention the term fishing. The tribes, it talks about hunting rights. It talks about the usual privileges of occupancy. But Henry Schoolcraft, who wrote that treaty, who was not a careful guy either, he was an acolyte of Lewis Cass, didn't bother to put in fishing. Now, if you look at the treaty records, fishing was probably the single most important thing to the tribes to reserve. It was the cornerstone of their subsistence and of their culture. And so when the treaty fishing rights cases were litigated in Michigan, it was extremely important for historians to tell that story. And the courts accepted the story given the strength of the record. These are just some of the ways in which history comes into our cases. I'll just talk a little bit before I end about the different ways in which history works in. In the ideal world, we start a case from the ground up. We're in a trial court, and we have an opportunity to build the historical record. And we work with historians in the way that I've been talking about, as expert witnesses. And I will say, and I don't mean to make this a pitch for experts, but it is, serving as an expert is a very demanding, it's very grueling, it takes a lot of time. Litigation is really, can be very scorched earth. But if for historians to make a difference in terms of the historical record, serving as an expert can be a wonderful way to do that, because what you ultimately end up with are court decisions that then get looked to as a very important part of the historical record. So it's a way to participate in the continued construction of history. So that's the ideal way, where we work with historians. You have these dueling histories. We try to tell the better story with the benefit of great historians. We don't always have that luxury, because sometimes cases come to us at an appellate stage. They don't involve a trial record if they're a criminal case. So the cases we litigated in the state of Oklahoma in recent years about whether the Creek Reservation continued to exist, which ended up going up to the U.S. Supreme Court and resulting in a Supreme Court decision that the reservation still exists. We got involved in that case at the appellate stage, and it was a case that came out of criminal proceedings, so there was no historical record told. In those situations, we find ourselves in the somewhat uncomfortable position of having to play historian and having to construct from the historical records ourselves a story to tell the court. Even in those situations, we like to work with historians as consultants to help us, because we're not professionals in this regard. But at every stage of litigation in our country now, history is all important, because the courts themselves fancy themselves to be historians. And we have a U.S. Supreme Court, which is not shy about doing history. Doesn't have the same sort of reticence that we do about doing it. We have a court that has a lot of originalists on it. Originalists, the whole point is to go back in history and try to discern what the original understanding or meaning was. And we have a lot of justices on that court who are not afraid to do that work themselves. Which makes it all the more important that we have historians working with us to tell those stories, to construct the narrative, to put guardrails on what the courts might otherwise do. So thank you again for the privilege of being here, and thank you really for the great work that we get to do with wonderful historians, which makes all the difference in our work. Thank you.
Ten minutes, huh? All right, I'll do my best. So I was inspired by a lot of different things in terms of the substance of my talk today. Long ago, Frank Edabagishik asked me if I'd ever heard of the Sweetgrass Treaty, which was a treaty from centuries ago between the Dakota and Ojibwe of what is now Minnesota. And, you know, they don't get along. Those of you who have Minnesota connections know this. I mean, the word for warrior in Ojibwe is Ogichida, and the word for warrior in the Dakota is also Ogichida. They're so closely related, they even use the same words to describe their fights together. But I never heard of the Sweetgrass Treaty. You can't find a historical record for it. I mean, maybe you can. Maybe it's just literally a piece of sweetgrass. You have treaties from the Northeast that are literally just beads or pieces of shells put together. We call it wampum. There's a language behind these materials that is not at all accessible to lawyers or judges who do not understand that or have not really had any experience with those cultures. And I started thinking about all the work that we did in those cases, treaty rights cases. And, you know, the work that Jim and Riaz have done and other historians like Greg and Richard and all these people all over the country, Helen Tanner, I mean, just amazing stuff, Barbara Lane. They're really looking at a historical record that almost exclusively includes non-Indian people. And, you know, Riaz mentioned on the Supreme Court, the originalists will look at the original public understanding of the Constitution, and the corpus of historical record consists almost exclusively of people who owned slaves and or benefited from or perpetrated Indian killing and dispossession. It's hard to find a good person in the framers or the founders. And those are the people they are the only people that matter. No women matter. Certainly no people of color, no men who were not who are not landed and wealthy, they don't matter. And I find this absence to be, as an academic and as a Native person, to be very troubling. I mean, when you get into litigation, you got to play the game. And I respect that. And I know that tribes actually do a really remarkable job of it. But there's a part of me that is really troubled by the cases where Indigenous people could easily testify about their oral tradition in federal or state court, but they will not be allowed to testify because everything they say is hearsay. Instead, we have to look to experts, more and more of whom are Indigenous at this point, but they're still looking at the same corpus of written material. Much of it is in English or another colonizer's language. We don't really hear what Anishinaabeg said in the opening remarks in the 1836 Treaty of Washington. We know that it went on for a really long time, and those of you who know Indigenous leaders know they might tend to speak for a while. And that's totally fine, but we really don't know. We do know that there was a treaty interpreter and some other people wrote a treaty journal who might summarize some of the things that Anishinaabeg would have said. I like to think that Anishinaabeg basically just spent all morning threatening Henry Schoolcraft and Lewis Cass and Andrew Jackson. That would have been awesome. But I think there's a part of that story that I strongly suspect is rooted in the culture. And that's the thing going forward, I think that we really need to start uncovering. And we can actually do some of that. I mentioned last night the logo here. You actually have some culture on the treaties themselves. Now, why would an Anishinaabe treaty signatory sign their name with the image of their dodem, their clan? That's because they are there effectively representing, say, the Muckwa Dodem, the Bear Clan. And they have a certain obligation within their community as well as to their clan. And the way the governments are structured is rooted in this philosophy. You know, and I was serious last night when I said humans in the universe are not as important as the animals that are around us. We aspire to be like them. And those animals aspire to be like the supernatural creatures or a thunderstorm, right? And so all of this is part of the culture. And I want to emphasize a few things, I think, going forward that I know will certainly inform the way I think about these cases and this historical record. Number one, I strongly suspect that the culture, Anishinaabe culture, and other indigenous cultures are imbued within the treaty language. Yes, it's all in English. There's not a lot, even in the treaty journals and a lot of the materials that we have to use in court in order to prove a particular point. But between the lines, there's an enormous amount of things going on. And I think you start to see that in Canada right now. In the last several decades, the Canadian Supreme Court has instructed attorneys and judges to take into consideration the oral tradition of Indigenous peoples for purposes of proving Aboriginal title and other kind of land claims, treaty rights, et cetera, et cetera. And that's all good and fine. I don't know that that will ever happen in this country in a meaningful way. I mean, when the infamous Wisconsin Potawatomi's case versus Houston, which was sort of the framework for what would become the Indian Child Welfare Act. The judge listened to tribal citizens from what is basically now known as the Hannahville Indian community explain their child rearing theories and traditions, and how an extended family relationship is actually a perfectly acceptable way to raise your child in a reservation or a Potawatomi community. And the judge said, I don't understand a single word you're saying, asked a Michigan State professor all the same questions, who answered with all the same exact answers as the traditional elders at Potawatomi, and that's what's quoted in the opinion, not what the elders said. And I think that's the kind of thing that we need to delve into. I'm also heartened and definitely inspired by something that Jim McClurkin sent to our family not that long ago, just probably a year or within the last year or two. And it was a deposition from an Indian Claims Commission proceeding involving Michigan Indian tribes, including my great-grandfather, Benjamin Mamagona, whose name was misspelled. We never would have found it. Mangona or something like that. And, it's one of the few times I've actually seen transcribed testimony from an Indigenous person who was around during at least the latter half of the 19th and into the 20th century. And that's a rarity. I'd like to see a lot more of that if it were even remotely possible. But my point being is that these treaties are, as Rob Williams explained, they are the creation of a kinship relationship between two effectively sovereign to sovereign nations, right? And that's something that is not really as well explored as I'd like to see it be explored, especially with Anishinaabe communities, in large part because, in Canada, the way their Anishinaabe people and scholars are talking about those treaties is that the negotiations were not really negotiations of terms, but they were a lesson by Indigenous people about this land that is at subject. The Indigenous people of a given place understand their role in, say, Anishinaabe, where we are now, as they're basically renters, to borrow a phrase from Tori Dolan, who was here earlier in another context. You guys know I do what I'm talking about. Don't worry about that. But this isn't ours necessarily. I mean, we Indigenous people might occupy a place and use it, but fundamentally know that it is not an ownership issue. It is not a pure ownership way in the way that you understand in Western political thought with John Locke and all those guys. We are stewards of the land. I don't really like that word, but close enough for our purposes today. And the negotiations are in part Indigenous people explaining to the newcomers, this is why the land is the way it is. And when you come into this land, we know there's nothing we can do to stop you, but you're coming. This is how you take care of the land. Listen to us and we can explain to you how you can live in harmony, Manoba Madzawin, or with the land, and how you can have a system of relational accountability like an Awandewin, where you actually understand the role of human beings in a given place and how to maintain sort of the harmony and balance and equality within the land. And that's what the treaty negotiations may, at least in part, have been with some Indian tribes, and they were basically saying, this is how you do this. When you do come in here, this is how to live with land. And, we know what they did when they came in. They deforested the entire landmass of what is now the state of Michigan, much of Wisconsin, much of Minnesota, all of Washington State, as far as they could go. And they did the exact opposite of what Indigenous peoples tried to instruct them to do. But I think it would be useful to uncover the cultural connection and the cultural philosophies that are imbued within the treaty themselves, even though they might not be written out in the English language. I think that's a goal, something to uncover going forward. And I really appreciate all the work that people do. I used to be a part of that. Winona used to be a part of that way back in the day before we retired at a young age from being lawyers. You remember those days when we were lawyers? But there's always a part of me that kind of hates it because it bothers me that we have to fetishize people who are long dead, who killed Indians, who took from Indians, who probably were slave owners and exploiters in other ways. And that's the basis upon which we have to litigate these cases. And I find that troubling. And I think moving forward, we should try to figure out a way to move away from that a little bit. You guys keep doing what you're doing for now. That's fine. We'll go back to you in a few years. Thank you very much.
So we have are these, can you hear me? Okay, good. I can't tell if it's actually on. You have to be quite close. So we have a few minutes, and I thought I'd kick us off with a question, just to provoke some conversation amongst the panelists before we turn to you all for your questions. And I think there are microphones also set up throughout the room. There's a gentleman in the back, but let's start with a bigger picture question for each of the panelists. So I was struck in each of your presentations about the emphasis on history and history of a particular kind, and the need for history in federal Indian law because the treaties themselves have vague and ambiguous language to them. And in a certain respect, I've lived my life in a world where federal Indian law has been treated as a very unique and often superstitious, sui generis field. So I thought I would start with a bit of denaturalization before getting to my question. So I thought I'd start with some other vague language. So nor shall any state deprive any person of life, liberty, or property without due process of law. Does anyone know is that a treaty? Because it sounds pretty vague and ambiguous to me. No, that's the 14th Amendment of the United States Constitution. And until recently, that part of the Constitution didn't depend as heavily on history and tradition as federal Indian law has. But I think we could say that language is pretty vague and ambiguous. And over time, history and tradition has come to mean that language restricts the ability of states to pass laws to regulate gun rights, for example. That's how vague and ambiguous it is. It's so capacious that we can now read it to mean that states can't regulate guns. And it's even so capacious in its history and tradition that the courts are now fighting over what history and tradition really means. Whose history and tradition counts? So getting into Professor Fletcher's presentation, where there are so many histories to be had. And in federal Indian law, we've been talking about and fighting about these histories and whose histories for so long that we've even developed a whole field of experts who have lived their lives doing this research and this research alone. But in the context of live litigation today on the Second Amendment and on that vague and ambiguous language in the United States Constitution, whose history and tradition is now getting fought about in oral argument live, including over whether or not the state of Hawaii could regulate gun rights in its own jurisdiction, and whether or not the laws of Hawaii, which became a state only in 1959, whether or not laws from before 1959, that history and tradition, even of that jurisdiction, counts. Instead, the court wants a, quote, national tradition, whatever that means. And that's a history and tradition that excludes all of those folks that Professor Fletcher was mentioning, those people on the margins, those people without political power to be able to pass laws. And instead, the Supreme Court is turning to seeing as authoritative, for example, a 1771 law passed in New Jersey, the colony of New Jersey. I know it's the 250th, so we can all reflect together on what 1776 really meant. But the national tradition of the United States didn't start in 1771. So the fact that we can see as those laws as more authoritative in the way we're pulling together this history and tradition than the laws passed in 1958 in Hawaii is a telling story about what the battleground of history and tradition really is. It's playing out live time. But my question for the panelists, it really focuses on not only what we can learn from these long tail fights about history in the context of federal Indian law, but also why we have lived with history and tradition for so long. So much so that we can now start to bring in the history and tradition of people who were truly dispossessed by the United States, where we can authoritatively start to litigate around bringing those perspectives in, because it's not unheard of for these treaties to be interpreted in the way that Professor Fletcher describes. And it's because of the litigation expertise of folks on this stage that we've gotten to this point. So we are all living, I think, in stage 0 of our own constitutional history and tradition. And so I'm hoping that maybe we can take federal Indian law as the canary in the coal mine for that experience and reflect a bit on why history, why vague language here rather than everywhere else, and what can we learn from that?
I always have something to say. You guys go ahead.
Well, I could start. Obviously, it's a great question. It's a big question. I think a couple of things. One, from a legal point of view, and I think something that is very important for us to all remember is that while it has been honored in the breach, the principle that tribes are sovereign in this country and have sovereign rights that predated the Constitution, that tribes actually were not part of the Constitutional Convention and therefore have rights which have been understood to predate it and not necessarily be constrained by it. That has been of fundamental importance, I think, to the survival of tribes in the way that we know them. Because in a lot of countries, in a lot of jurisdictions, Canada is an interesting counterexample. There wasn't that sort of principle. Now, as I say, that principle, as we all know, has been honored in the breach, and tribes' pre-existing sovereign rights, tribes' treaty rights have often been disavowed, abrogated, ignored. But through it all, and somewhat remarkably to me, that principle has not been erased. And that gives those of us who are litigating these issues in the legal world and historians, it gives us an anchor. And that anchor is that no matter what's happened in the last 200 years and no matter how much there's been in terms of the violation of rights, there still is this core set of rights that all grows from the notion that tribes are independent sovereigns. And that means that mining the history remains relevant, because no matter how much there's been in terms of the washing away of rights and the washing away of history, there's still that fundamental anchor to go back to. So when we were litigating the McGirt case, the thing there is, if you looked at the more recent history of Oklahoma, if you took Oklahoma from 1880 onwards and the advent of the real influx of settlers and then the discovery of oil and statehood, which all happened around the same time. Between 1880 and 1920, you had these overwhelming historical forces, which meant that these reservations that had been promised by treaty as separate lands on the end of the Trail of Tears, they were overrun. And if you just looked at them, they didn't look like separate, set apart reservations anymore. But because of these fundamental legal principles and the idea that tribes retain rights even in the wake of those kind of forces, it made it relevant for us to go back and mine that history and to say to the court, no matter what happened, Congress never stepped in and disestablished these reservations. So I think that's one, not necessarily the only reason, but I think a principal reason why we are able to hang on to history and construct narratives, given all the limitations that we live with, and I'm just a mere lawyer, right? So we have to work within this system where the history and the records that we're able to base what we do on, if we want to win, we are constrained, but at least we still have that ability.
Yeah, agreed. Thank you for bringing up the 14th Amendment Due Process Clause. I spent a lot of time in tribal court cases dealing with claims rooted in tribal due process clauses or the Indian Civil Rights Act. We're borrowing this language from the United States Constitution. And the funny thing is, the interpretation of the due process clause in the clauses in the U.S. Constitution, I characterized to my students, and I'm totally being unfair, but you know how I am, as basically being the principle there is the bare minimum the federal government or the state government has to do before they fuck you over. And I always think with tribal nations as a judiciary or policymakers, lawmakers in tribal communities, we can do better than that. But I think it's useful to think of the U.S. Constitution as kind of a treaty between the federal government, the state governments, and the people. It's what it's supposed to be. And if you looked at treaty principles that we're talking about today, Indian treaty principles, it would be amazing to see how the U.S. Constitution would be interpreted in light of the understanding of the people who actually are effectively supposed to be the beneficiaries of the U.S. Constitution. And we look at the original public understanding, and typically that means the first place you go, if you have to, is the Federalist Papers. And those are just a bunch of op-eds, put on social media in 1789 or whatever. The one that is basically the key source to the notion of federal sovereign immunity, which dooms tribal claims against the United States again and again and again, is Federalist Paper number 81 by Alexander Hamilton, and it's not in the frickin' musical, it should be. But it begs the question, like, who the hell was voting for this thing? He basically says, I've been asked by concerned people that you might be able to sue the government for things when they screw people over. Absolutely not, he says. We would never allow for that. It's just imbued in the structure of the Constitution. You can't sue the government unless the government consents. Thank goodness for that, right? And we voted for that? Do the people vote for the inability to make their government accountable in court? I don't think so. I know who voted for that. Those guys I was telling you about on the dais a few minutes ago. But if we had like a people's canon of interpreting the Constitution, it would be a radically different document. We'd have a radically different government and maybe even a radically different society. I don't know what that would look like. Probably we'd be sitting around a lot watching Happy Days a lot more than we usually do. But I think that tells you a lot about how the application of history. That Alexander Hamilton, a guy who was never elected to a single thing in his life, and owned slaves, what is our source to all of this? And it's shocking to me. I would love to see more on the indigenous side in treaty rights, and we're doing some of that now with in tribal judiciaries of incorporating principles of Anishinaabe philosophy, legal principles, and some of our history into the interpretation of these statutes that we borrowed from the colonizer. Things like the equal protection clauses, freedom of speech, freedom of religion, that sort of thing. All of that stuff can be interpreted in light, those are ambiguous terms, interpreted in light of our understanding and our culture. We have, in a lot of respects, tribal judiciaries, tribal lawmakers, legislatures have a blank slate. They can start with a borrowed law and they could move it into a totally different direction in a much more normatively positive way than you will ever see, I think, going forward in federal or state polities.
I'm an anthropologist and not a lawyer, so I have a little different perspective, but Matt's thinking shapes the way I see my history too. He talks about seeing what's not there of the indigenous community. And last night I thought about that, and I thought about the first time I met the Mille Lacs community. And I met the Mille Lacs community, I think, around 1984. And I went there with a guy named Chuck Cleland, and we were invited to meet the tribal council. And the tribal council met in a little one-room trailer, and the one-room trailer had one light bulb hanging down, and sometimes the light bulb worked and sometimes the light bulb didn't work. But we went there, and the whole council was there, and they said, "So you want to work for us, do you? Okay, you better know who we are." And if you don't want to do this, you should leave right now. But they sat down and told the Ojibwa creation story for 3 hours in Ojibwa. And then, after that was done, they said, aha. And then they told the creation story for 3 hours in English. And then they said, do you want to work for us? And we said, yeah. The history drove the reservation case when they had been told by Minnesota for 150 years they didn't have a reservation. It had driven the hunting and fishing rights case when the state of Minnesota had told them they didn't have hunting and fishing rights. The history is central to the sovereignty. And if you don't tell that history, there's nothing there. Their identity comes off a television set or off a casino slot machine. So that history is really important. We're talking about the 1836 treaty and the reservation. And you don't know this about the reservations in Michigan, but in 1870 was the first land rush on a reservation. And it happened in the 1855 treaty reservations. And the former governor of Michigan became the Secretary of the Interior and decided that ambiguous language in the 1855 treaty meant that the treaty reservations were going to disappear. And so there was a rush at the local land offices, and people camped out, and they claimed the land on all the reservations, including all of Emmett County, Leelanau Peninsula, the Manistee River, 70 miles in, the Muskegon River, all the way in, and it was gone in one day, just one day, and the tribes refused to go. I'm not that old. But I started hanging around Little Traverse in the 1970s, and Matt talks about Frank Edward Giesick. My first experience with Frank Edward Giesick was in 1959. Frank Edward Giesick was a dancer in the pageant at Little Traverse, and I got to watch him dance. And it was about the history, and it was about the history of the reservation. And everyone says there's no reservations because the state of Michigan says there's no reservation. But I read the treaties, and Little Traverse is an important place to the Ottawas. It's the center of Ottawa culture. And I started going back up there seriously in the late 70s, and I started meeting people in the 1980s. And Eric Hemingway, who's one of the directors of this program, Eric was 5 at the time, and his mother was on the tribal council, and she was working with a guy named Sam Keeway, and Sam's niece is in the audience today. And they sat me down and gave me the history of the reservation. And a guy named Pine Showman was just all over the world. And he incorporated ideas from Walpole Island First Nation, which was never ceded to anybody, and from Wikwemikong, which was never ceded, so the hotheads on those islands were feeding these guys ideas. And those stories were there. So Eric grew up with those stories, and I sort of grew up with those stories. And without those stories, all of the people who lived on the Little Traverse Reservation in the multi-million-dollar houses that were built on top of the Ottawa cemeteries, on top of their villages, on top of their churches, would have disappeared. So getting to that history is just really critical. And I've never participated in an event like this where that was ever a part of the function of the panel. So thank you for doing this.
And with that, I think we can open the floor to questions from you all. There is a gentleman walking through the center aisle with a microphone. My only hope is that there's a rising intonation at the end of your question that makes it at least sound like a question.
Hello, I'm Disha Miles. I have a short question. I see your shirt says land back, and I was just wondering what your thoughts were about what that would entail to you.
There's a lot of state and federal public lands out there. A lot of it isn't being used for anything. I'm going to exclude like Yellowstone. That's nice, but a lot of that, you know, the people out west really hate that the federal government owns all their land. But I don't know if they would hate it more if that land was returned back to tribal nations. Because what you see are terrible things like Oak Flat, where there are sacred sites, entire religions are rooted in a place, and federal government just gives it away to a mining company for destruction, for political patronage purposes. And so I think that's a step. You know, I was confronted with a complaining assistant secretary one time named Kevin, and he said, I got $1.5 billion worth of water rights settlements sitting in Congress right now, and the Congress is complaining they don't have $1.5 billion to pay for all of that stuff. And I said, you do actually. It's the Black Hills land claim. It's $1.5 billion. This is 15 years ago. Just sit in your treasury account. Make a switch. Give the Black Hills back to the Lakota and the other tribal nations that were parties to that case. And actually, it was just Lakota. And you got your solution. He just laughed at me. And this is an Indian guy. And it's just not politically palatable, but you have to open up the door and think about what that means. We've got a lot of state and federal public lands here in Michigan, and that's where the inland hunting and fishing rights are for the most part, especially in at least the 1836 ceded territory. So it means a lot of different things. But you got to remember something, and I'll invoke one of my favorite anecdotes from Sam Deloria, who's one of my mentors, and he said, well, imagine a scenario where the Indians won and all the white people have to go back. And you see the boats going off into the distance across the Atlantic, the Pacific. There'll always be some Indian people on the shore going, come back here and fulfill your treaty rights and your trust responsibilities. Yeah.
Hi. Okay, my question is back to you, Matthew. All right. Yeah. I've noticed when you're talking about, and this is also obviously not to decenter the conversation that we're having now, but I do notice that, and this is the first time I feel like I've heard it being talked about this way, the notion to slavery and how that kind of builds off of this dispossession of Native Americans here in this country. And I kind of just want, maybe if you can like give a paragraph to explain why, I guess now is this so important for us to continue to connect histories? Because like I've said, I feel like this is something new that I've been hearing. Thank you.
Yeah, sure, I'll give it a shot. I mean, it's always been important, and you know, you can just pick anything, but look at the birthright citizenship case, right? I mean, the Reconstruction amendments that followed the Civil War, 13th is supposed to prohibit slavery, 14th is supposed to undo a lot of the problems associated with slavery, guarantee rights to everybody born in the country. 15th Amendment is voting rights. What are you got to remember what the purposes of those things are, and you know, the 14th, 50th, and 5th, all of them really are designed, but the 14th, especially the second section of the 14th Amendment, is supposed to eradicate the principle that in the South, for purposes of proportional representation, the South could count 3/5 of all of the persons, which is that infamous euphemism referencing enslaved persons. And I think that's not part of the discussion in birthright citizenship. You know, when you talk about using a corpus of evidence that's rooted in the people who owned slaves, even as part of the ratification of the 14th Amendment, you know, that it was a huge stain on the United States. So I think that to me infuses everything with the U.S. Constitution. I think if you look at the Bill of Rights, what you're going to see is a bunch of protections for people who are slave owners. What it really protects probably more than anything else, except for Indian people, is the taking against the prohibition of the taking of private property. And that included at that time, unfortunately, included enslaved persons and things related to that. So to me, that's a goal and purpose we don't like to talk about, and most people will reject. But that's the reason the Constitution is written the way it is. And not as bad, but I think that the things that are included in the Constitution relating to Indians and Indians not taxed, Indian tribes and Indians not taxed, that stuff is in there for a different reason, which is ostensibly it is, you know, to enable dispossession of indigenous lands, but in a lot of respects, it is a manifestation of international customary law that recognizes that there are relationships between sovereigns, that it can exist, where one is located inside the exterior boundaries of another, and they have a relationship together. We often refer to it as the trust responsibility now. Originally, it was sort of called a duty of protection or a protectorate, whatever you want to call it. That's why it's in the Constitution. We can't even talk about that to the Supreme Court. They won't acknowledge the fact that the Indians Not Tax Clause and the Indian Commerce Clause comes from international customary law, and not in a meaningful way. And so that's, I think, one of the reasons we have to keep talking, unfortunately, we have to keep talking about things like slavery.
Could I also just develop a little bit on something that Professor Fletcher mentioned earlier with the idea of interpreting the Constitution, and particularly the 14th Amendment, and maybe even also the 19th Amendment, like a treaty, rather than, as we're thinking about it now, originalism only looks to the people who were empowered to ratify it, which always puts that text in the context where we're looking to the exclusionary community for the meaning of the text. So if you look at the 14th Amendment, the 13th Amendment, the 15th Amendment, all the Reconstruction Amendments, as a treaty with the people who were excluded, and including within those amendments, this is closer to Dorothy Roberts' abolition constitutionalism, including with those in those amendments the perspectives of the peoples who were excluded and the terms that they bargained for to join the United States for the first time as full-fledged political members. There's a way in which, if you look at the history of Indian law, the resistance strategies within the Native community, I think there's a broader constitutionalism there that can really speak to ways of liberation, not just across communities who were subordinated by the United States, but to really broaden our constitutional culture writ large. And there are little lessons like this all over the place that I think speak to the experience of all peoples within North America, and not just specifically to Indigenous peoples, although it's a broader strategy that has been developed largely within one particular resistance movement.
I wanted to ask a question and a follow-up to a reply about public lands under the Bureau of Land Management. There's 270 million acres of what I consider Native American land, which is used for mining operations, and it's been used for a long time. I've supported a lot of environmental groups to try to fight that in court, and I often wonder why more Native American attorneys or attorneys in general don't fight that more in court, because that Mining Act of 1872 says that if you find any mineral on any land, Western land, and of course sand is a mineral, so that takes in all of the Western lands. They've also included Florida into the Western lands, which is kind of interesting to me. And on the environmental groups and then Native American groups, of which I've supported a long time, and I've been an activist a long time over this. And I finally came to this conclusion about it. And so my question to you is, this land that's leased, it used to be until about 1990, you could purchase that land for $5 an acre. And millions of companies purchased that land. How come environmental groups and Native American groups don't lease that land for the very minimum lease and tie that land up each year, just keep releasing it? Because all the time funds I've done for supporting it, we've lost or it's been not effective in courts. So anyway, how come we don't use that particular strategy? Why don't we lease the land and tie it up forever?
I don't know anything about the mining. I've heard of this. I want to emphasize something that I think that you're raising, which is the tribes, especially now, have a lot more agency than they ever did. We've been talking about sort of the treaty period. I think tribes had a lot of agency back then. There weren't as many non-natives in the area. There weren't not as many Indians really, for that matter. There wasn't a lot of outside commercial pressure on what was going on. That came quickly, and that's why we had deforestation in the state of Michigan. All sorts of things happened all over the place. But now we've come full circle in a lot of respects. And I like to think that tribes really should be thinking of ways about doing things like what you suggest. I don't know anything about what you just said, but if it was that easy, I think tribes would have done it by now. You assume that they wouldn't. I think if there's something else going on, I'm not a natural resources professor. There's one in front of me. She's busy doing something else right now. She could probably answer that better than I can. But I appreciate you bringing up the point that tribes really have an opportunity to do certain things. You know, we're not a canary in the coal mine anymore. You know, we're not a little bird inside of a cage that you bring into, you know, a dangerous area to see if it dies. And so the sacrifice there is to benefit all the non-canaries. And you know, we have much more agency now, and I think that is I'm heartened a lot by that. And so, you know, I like to, one of the great metaphors that environmental justice advocates, especially those who are indigenous, have really borrowed from American federalism type laws, the notion of laboratories of democracy. You know, there was this notion a century ago, I think introduced by Justice Brandeis, maybe when he was a lawyer at the Supreme Court, saying that every state has the opportunity to experiment. And some states are going to mess things up, and you don't want to do that, so let that be a lesson to the other states. And some states are going to come up with something incredibly creative that everybody wants to borrow. Well, that was when there were 50 states, and now they're kind of all flattened out in a lot of respects. But there's 575 federally recognized tribes, most of whom are operating under an incredible amount of resource pressure and other kinds of pressures, and they have to come up with incredibly difficult and creative ways of governing. And you're starting to see the tribes being the source of the laboratories of democracy, especially when it comes to environmental justice, and they're exporting it outside the reservation, which is really critically important.
I think with that, please join. Yep, he really closed it out there, Professor Fletcher. So please join me in thanking the panel.